Hey everybody, it's Chris Clark with discgolf.law. What is going on with Natalie Ryan's lawsuit against the PDGA and the Disc Golf Pro Tour? Over the past week, there have been a lot of court filings in this case. Now, many of you probably remember back in February, a complaint was filed. This is the legal document that initiates a lawsuit. Natalie Ryan's attorney filed the complaint against the PDGA Disc Golf Pro Tour and against 1000 Rated Productions, the production company that runs the OTB Open. Many of you may already know that when a lawsuit is initiated, the defendant has a certain amount of time in which to respond. It's typically 30 days in most states. Some states it's different. It's fairly customary for a defendant to be allowed additional time, typically an additional 30 days, in order to file their answer to the complaint. In other words, their response to the allegations made in the lawsuit. Natalie's lawsuit was filed on February 22nd, 2023. So many of us have been wondering, where is the response in this case? As I am recording this video, it's the morning of May 9th. So one would think certainly the defendants not only would have had adequate time to respond, but would have been legally required to respond by now in order to meet their deadline. Well, it turns out that the defendant's response actually technically is not due yet in this lawsuit, and I'll explain why in just a minute. In Natalie's original lawsuit, two of the things that she asked for were, one, that Natalie be permitted to play in the FPO division in the OTB Open in Stockton, California. The second thing that they had asked for was that the Disc Golf Pro Tour and the PDGA not be permitted to conduct business until this matter is resolved. We've all kept our eyes on the calendar. We all know that the OTB Open is happening this coming weekend. Sure enough, on May 3rd, Natalie's attorney filed a motion for a temporary restraining order, asking that the court force the OTB Open to allow Natalie to play. This is a filing for what we call equitable relief. We're asking the court not to award anyone some money at this time, but they're asking the court to require a party to actually do something. That's equitable relief. In these situations where there is such a tight time frame between the time that this is filed and the time that action must be taken, this is a form of relief that is referred to as ex parte. In other words, we're really asking the court to do something without giving the other party time to respond. That is a very high legal bar that needs to be met in order for a court to award this type of relief. These situations are reserved only for emergencies. In our judicial system, we believe it's only fair that both parties have a chance to be heard. There are several things that a party must show in order to successfully obtain this type of emergency ex parte relief. One example is they have to show that immediate relief is necessary. And in this case, you can see why they're asking for that, because if they don't get immediate relief, the OTB Open is going to be held and they will have lost their chance to get what they're asking for from the court. Another point they must show is that they are likely to succeed on the merits of their case. They have to prove to the court in the absence of this other party that, hey, here is the evidence that we're going to show, and assuming that we present and prove this evidence, we're likely to win. In the many pages of filings that have been made, the request from Natalie's attorney for this temporary restraining order did contain a significant amount of additional documents to support their allegation that they are likely to win in this case. One of the documents that Natalie's counsel submitted in support of their motion is a decision from a federal district court in Minnesota. J.C. Cooper versus USA Powerlifting. I won't go into a lot of detail. This court opinion is very long. There are questions about the degree to which it would apply in this case, but the facts are quite similar. There is a professional athlete that was born male, assigned the gender male at birth, and then transitioned as an adult and now identifies as a female and was seeking to compete in the female division in USA Powerlifting. This was a claim made under the Minnesota Human Rights Act, very similar to Natalie's case that is being made under the California Civil Rights Act. So USA Powerlifting has a policy that prohibits competitors who were born male from competing in the female division in powerlifting. Suffice it to say, there are similarities to Natalie's case. Once we see all of the documents that will be filed by the PDGA and the Disc Golf Pro Tour, some have been filed already, which I'll talk about in a minute, but eventually we will likely see a full answer to this lawsuit from these parties. And I expect one thing that we will see is that the defendants will attempt to distinguish the facts in Natalie's case from the facts in the Minnesota case. I think there are a number of ways that they could successfully do that. And this is why lawsuits get heard by judges and by juries in situations, what we call cases of first impression, because this situation with Natalie, although yes, it does bear similarity to the Minnesota case, it has its own unique and distinguishable elements to it. The bottom line is that J.C. Cooper, this transgender powerlifting athlete, did prevail on most of her claims. Now, I want to circle back to the timeline a little bit and talk about why, even though 2.5 months have passed, we haven't yet seen an official answer from the Disc Golf Pro Tour, from Thousand Rated Productions, or from the PDGA. That clock starts ticking when you are required to file an answer to a lawsuit within a certain amount of time once you have been served with the court documents. And it appears in this case that service was delayed. The responsibility for that, at least in the court documents that we've seen filed from the PDGA, lies with Natalie's attorney. In fact, the PDGA's documents that they filed actually place a lot of significance on the timeliness with which Natalie's attorney has acted in this case. The lawsuit that Natalie filed was entered on February 22nd. However, in the court filed documents, we see that the defendants were not served until around April 10th. You'll see that in the view of the defendants, the time period that they have to respond, which in this case I believe is 60 days, that clock doesn't start running until April 10th. Why would somebody file a lawsuit in February and then not serve the defendants until April? There's a lot of potential answers for that. Giving Natalie's attorney the benefit of the doubt, there could have also been some strategic reasons for that. In the court documents, Natalie's attorney claims that he was in settlement discussions with the PDGA and the Disc Golf Pro Tour at least until late March. The court documents claim that, at least with respect to the PDGA, it was not until March 22nd that it became apparent that these settlement discussions were breaking down and were not going to be successful. On the one hand, Natalie's attorney may have been doing the defendants the courtesy of not starting that clock running to file a response because he believed they were having productive settlement talks. According to the defendants in this case, their answer to Natalie's complaint that was filed in February is actually technically not due until June 13th. Natalie's attorney has filed this emergency request to require the defendants to allow Natalie to participate in the OTB Open. What did the court say and what did the defendants say? We are not going to consider this ex parte. In other words, we're not going to leave out the defendants from this process, but we are, in light of the timing, going to impose an expedited time frame to hear this matter. As I said, Natalie's motion filed on May 3rd. They said, defendants, we need to hear your opposition to this motion. It's got to be in this court filed by May 8th at noon Pacific time. So that was just yesterday. The defendants, at least the PDGA, filed a significant, substantive, hundreds of pages long response to Natalie's request for this temporary restraining order. Documents in the court file have said that the defendants believe that Natalie's court filing for this TRO is untimely, that it is contrary to existing law, and that it is frivolous. They said Natalie waited too long to file this temporary restraining order. The dates for the OTB Open were known at some point last year. The PDGA policy that Natalie is challenging was adopted late last year, and this lawsuit was filed in February. And so now, why is it 1 week before this event that the court should consider this an emergency and allow this temporary restraining order to be imposed when it could have been something that would have had more time had Natalie's attorney acted sooner in filing this request? The PDGA went on to say that, look, we're entitled to rely on science and established a science-based policy imposing different eligibility criteria on transgender versus cisgender women. They said that their process was science-based and was transparent, and furthermore that Natalie is not likely to succeed on this claim, in part because Natalie has not shown sufficient evidence that this was intentional discrimination. As an example, the National Women's Soccer League, which has California teams, has adopted a policy that limits trans women's participation based on testosterone levels and other factors. The PDGA went on to cite other examples in other sports where science-based policies imposing different criteria for trans women and cisgender women have been used. The PDGA also argues that the PDGA is not a business establishment, as that term is used in the California Civil Rights Act, and therefore the requirements of the California Civil Rights Act don't apply to it. There is not a clear definition of what a business establishment is or what criteria must be met in California in order to qualify as a business establishment, but the California Civil Rights Act does apply to business establishments in California. PDGA says that's not us. The PDGA and the Disc Golf Pro Tour have both maintained the point that Natalie is not prohibited from competing in Elite Series events and PDGA majors, that she is welcome to compete in the Mixed Pro Open division. Natalie herself has said competing in the Mixed Pro division, which currently is nothing but male competitors, would not be an option for her because she cannot effectively compete against male competitors at the highest level. This is an interesting point, and I think Natalie's got to be careful with this. On the one hand, as someone who was identified male at birth, she is in some ways making the same argument that the current group of FPO players is making about allowing transgender women to compete in the FPO division, which is that biological males have unfair athletic advantages over those born female. So what happens now? As I mentioned, today is May 9th. That's the date that I'm recording this video. Natalie's counsel must file a response to what the PDGA filed by noon Pacific time today. Assuming nothing changes, there will be a hearing in court on this matter tomorrow, May 10th at 9 a.m. Pacific time. The OTB Open starts on Friday, and the court is going to hear arguments on this tomorrow morning, Wednesday at 9 a.m. So things are going to happen really quickly in this, and we should know something by mid to late day tomorrow as to whether Natalie's motion to allow her to compete in the OTB Open will be successful. Stay tuned to the channel. We'll be giving you updates. Like, subscribe, follow, and as always, we love reading your comments, so feel free to let us know what you think.